Today I'd like to talk about an effort to give clients another advantage in this ongoing debacle of mortgage foreclosures. And what I'm going to talk about is Section 57105 Florida statutes. Some of you have already gotten memos from me with regard to this matter, but I wanted to make sure that this was available for anyone to see. What is 57105? It's a portion of Florida statutes which provides that if an attorney files a lawsuit in what I'll call bad faith, an attorney for any defendant up to the time of trial may make demand on the attorney representing the plaintiff and give that attorney 20 days within which to dismiss the lawsuit. And the grounds for the demand basically revolve around the fact that the lawsuit as filed does not represent either, is not based on good law or is not a reasonable argument for an extension of existing law. And what we're finding with a great number of these mortgage foreclosures that are being filed is that the plaintiff files the lawsuit and attaches documents that show that the plaintiff has no interest in the property that's being foreclosed on. So as a result, as a technical matter, the plaintiff has no right to bring the lawsuit. And the filing of that demand, actually, before it can be filed, notice has to be given to the plaintiff's lawyer 20 days in advance. So, in advance of the time that the motion is filed with the court. In other words, it gives the attorney the time to look and see, gee, are we in order here? The other interesting part of the situation is that the Florida Supreme Court or an appellate court, I forget which one, has ruled that when an attorney receives a 57105 demand, the attorney is obligated to write to his or her client to explain the fact that there is now a conflict and that the client must either sign off on the conflict, acknowledging the nature of the conflict, or is entitled to waive, or is entitled to get other counsel. Now, why is there a conflict? Because if the demand is made and the lawsuit is not dismissed, and then the motion to dismiss is filed, and the motion is granted, then attorney fees are awardable against both the plaintiff and the lawyer. And so what does this mean to an association? It means that when I'm representing a client where there's a mortgage foreclosure, and as you know, these mortgage foreclosures are taking forever, and I determine, based on reviewing the file, the complaint, that there's either no assignment of the mortgage that was filed with the complaint or reasonably thereafter, or an endorsement of the note, or what's called an along to the note, it's ripe for making demand on the plaintiff and the plaintiff's lawyer to either dismiss the case or face sanctions. And if you get a request from me, if you're one of my clients, and I ask for that approval, it means I've already taken a look at your situation and it falls within those parameters. Now, the best part of this situation is that there are prevailing party attorney fees if we are successful in making the argument. If we're not successful, there's no fees that go back to the mortgage company, the plaintiff in the lawsuit, or the lawyer. So what does this do to wrap it up? First of all, it provides the association with an avenue to fight back against these bad faith mortgages and to do what needs to be done to protect your interests and move forward with your own foreclosure or money judgment, which I'll talk about in another segment. Number two is it reminds the lawyers that they better be careful before they file, because they're not going to be able to just throw together some sort of tranched note from a note and mortgage from a collateralized debt obligation or a collateralized mortgage obligation, and assert that the servicer on the sold and sold and sold and sold security product actually has the legal right to file the lawsuit. So they need to scramble to either find the assignment, which is fine, and get it filed with the court and move forward with their action, or they have to dismiss it. And thirdly, they're going to face legal fees, and we do this on a full contingency for our clients. So I urge you to pay attention to this matter, to take it seriously, because we're going to move forward with our clients and aggressively move to protect their interests. We'll see you next time.